In the northernmost reaches of British Columbia, a momentous battle is unfolding. Since time immemorial, the Tahltan First Nation have lived in the area, and despite 2 centuries of colonial pressure, they have continued to assert their autonomy. Now, in the 21st century, the Tahltan are fighting for what could be a new status quo in Canadian Indigenous relations for generations to come. The traditional territory of the Tahltan is a vast area comprising over 11% of the province, and its rich mineral resources have drawn in many mining operations. Currently, the most pressing conflict between the Tahltan and these operators is over jade extraction. In contrast to other operations, there has been a marked lack of consultation with these mines, and they represent a distinct threat to the Tahltan, both environmentally as well as archaeologically, as will later be shown. The colonial context of British Columbia is also crucial in understanding the full dimensions of this dispute. Due to the lack of treaties signed by the province with any First Nations, the assertion of Aboriginal land title plays a particularly key role. Meanwhile, the legacy of the gold rush in BC has left behind mining legislation which still heavily prioritizes staking claims over land ownership. Finally, with the UN Declaration on the Rights of Indigenous People, a backdrop of global Indigenous rights recognition now permeates increasingly. Under the banner of terra nullius and the discovery doctrine, which held that the lands in North America were unoccupied and therefore belonged to the European state that, quote, discovers them, the explorations of James Cook, George Vancouver, and Alexander Mackenzie in the 1790s marked the beginning of the colonial era in BC. While limited to the coastal areas at first, as the gold rush displaced the fur trade in the mid-19th century, settlements began encroaching further and further into the interior. The frenzy for gold prompted what are known as free entry staking laws in the province, which allow for virtually anyone to stake a mining claim virtually anywhere. Now part of BC's Mineral Tenure Act, with few exceptions, these provisions give prospectors the right to enter and explore, and, if minerals are found, the right to establish a mine. Meanwhile, landowners have little more than the right to be compensated as they are removed from their property. Finally, an amendment to the Act in 2005 allowing for online staking has led to an explosion in mining claims. Rich as the province may be in minerals, BC is home to a particularly rich diversity of Indigenous peoples, speaking over 30 different languages. Very few of these nations ever signed land treaties with the Crown. As quoted on the top right, leaders of the Tahltan Nation adamantly declared in 1910 that the Canadian government had no right to their traditional lands. In spite of this, the Federal Indian Act would force many BC First Nations onto reserves, expropriate their land, and smother their culture. And yet, in the mid-20th century, the winds of change brought increased Indigenous solidarity, and at least for some non-Indigenous, a greater awareness of these injustices, along with a willingness to listen. A number of landmark court rulings, as well as the Charter, established the modern foundations of Aboriginal land title in Canada. The Supreme Court in the 1973 Calder decision, while splitting on the question of whether it still existed, nonetheless affirmed that at least prior to colonization, Aboriginal title did exist. The passage of the Constitution Act in 1982 then went on to entrench Aboriginal rights under Section 35. 2 years later, the Guerin case established Aboriginal title as a pre-existing sui generis, or unique right, alienable only to the Crown, which may only use it in the interests of Aboriginals. It was in 1997, with the Delgamuukw case, that a 3-part test was established for proving Aboriginal title, as well as the conditions for infringing upon that title, one of which is the duty to consult and accommodate the Indigenous nation to the extent of the infringement. This issue of infringement leads us up to the present day. The traditional area of the Tahltan Nation is known as the Golden Triangle of BC, due to its vast mineral wealth. Importantly, however, mining in the region was not something new with the arrival of Europeans. The Tahltan themselves traditionally mined obsidian to make weapons and other wares, and currently they play an active role in the industry, with many Tahltan working as miners, and their central government having signed multiple benefit agreements with mining companies. In recent decades, jade has become a major commodity, and numerous permits have been granted for its extraction under the Mineral Tenure Act, prompting a TV series called Jade Fever. The rush for the greenstone has brought serious problems, however. Unlike other mining operations, no agreements with the Tahltan have been signed regarding jade extraction, and consultation generally has been minimal. Jade operations are also typically smaller in scale, which means that assessment for archaeological remains can often be foregone. One of the requirements in proving Aboriginal title is evidence of continued occupation, and so any discoveries could prove vital in support of the Tahltan's claim to the land. Furthermore, abandoned machinery, shipping containers, and discarded boulders threaten the ecology of the land. In short, these operations are a distinct threat to the Tahltan and are of no identifiable benefit to them. Chad Day, the current president of the Tahltan central government, has delivered letters to jade miners expressing the First Nations' lack of consent to the projects. While consent is not legally required, this is set to change in the coming months and years, as will soon be discussed. Before we examine this shift, however, it will be helpful to look at another challenge the Tahltan have faced recently in order to further illustrate what is at stake during these conflicts. Back in 2014, the BC mining company Doubleview Capital received a permit to begin exploration within Tahltan traditional territory in a region known as Chesley, which is considered sacred. After obsidian fragments were discovered in the area, Doubleview's permit was amended, requiring further archaeological assessments to be made before drilling began. Against those requirements, as well as opposition from the Tahltan, Doubleview began drilling operations. Soon after, Day and a few other members from the First Nation flew out to inform the miners, many of whom were Tahltan themselves, of the situation, after which they ceased working. Doubleview then filed an injunction against Day for allegedly interfering with the operation, though the Supreme Court of BC found that because Doubleview's right to drill was dubious in the first place, Day could not have interfered with that right, and so the case was dismissed. While this was something of a victory for Day and the Tahltan, Doubleview still remains active in the region. These two conflicts demonstrate how Tahltan land rights, as well as archaeological evidence of those rights, can be threatened and defended. But even with a recognized Aboriginal title to the land, the minimum requirement for its infringement remains in the realm of consultation and accommodation. However, this is set to change. In 2007, the UN General Assembly passed the Declaration on the Rights of Indigenous People, a comprehensive affirmation of Indigenous rights relating to land, self-government, traditions and culture, as well as many other areas. Canada at the time did not sign the declaration, citing concerns over Canadian sovereignty, though by 2010 officially endorsed it as aspirational. In 2015, the Truth and Reconciliation Commission listed ratification of UNDRIP as one of its 94 calls to action, and the following year Canada officially adopted the declaration, promising to implement it. It was in 2019, however, that the BC legislature passed the Declaration on the Rights of Indigenous Peoples Act, which guarantees the eventual alignment of BC's laws with UNDRIP. There are a number of uncertainties with the BC Act, as well as a similar proposed federal law. In fact, DRIPA is really only a first step towards actually bringing in the comprehensive changes that UNDRIP espouses. With that said, however, one of the main cornerstones of the UN Declaration is the standard of free, prior, and informed consent in dealings that affect Indigenous rights, and Section 7 of the BC Act provides for proceedings in this way through joint and consent-based decision-making. Broadly, there are three main models for this kind of framework. The first is to form separate jurisdictions, by which authority is split clearly between the provincial and Indigenous leadership over different areas. Here, consent is achieved at the outset by those jurisdictional lines being drawn. The second model prescribes jointly run structures, with both the Indigenous nation and the Crown establishing a decision-making board together, under the laws of both parties and appointing members to it. The board is given a direction and the final authority to make decisions within that area. The third model is distinct in that consent is achieved at the end of processes. Here, the Indigenous nation and the Crown each make decisions within their own legal and governance structures, as well as any process mutually agreed upon. Where those decisions do not align, there will be established mechanisms to finalize an outcome, such as binding forms of dispute resolution. The implementation of DRIPA is likely to incorporate all three of these models, though perhaps as important as the above are considerations of what consent is not. Contrary to our notions of consent as being a very progressive idea, is the simple fact that it is actually nothing new. The Royal Proclamation of 1763, which affirmed many Indigenous rights, stands as a testament to the historical basis of consent-based treaty-making. Consent is also, like all rights, not absolute. It does not grant veto power to Indigenous nations over anything that might affect them, but rather attempts to restore the nation-to-nation relationship which characterized the earlier periods of European contact. Lastly, while DRIPA does raise questions, there are good reasons to view consent as a way of removing uncertainty, not creating it, as it fills in many of the gaps left open by legislation such as Section 35 of the Constitution. Looking ahead, it is clear that DRIPA and other such legal frameworks will take some years to fully implement, and the BC government is currently in talks with First Nations to decide what it is going to look like. While we cannot imagine that the fight for Indigenous rights in the province is now over, at least regarding the Tahltan Nation, we can recognize the recent success in a deal struck with the province just a few weeks ago. In it, their land title, along with numerous rights, were affirmed, and they were provided with a $20 million land use grant. Further DRIPA-based negotiations are set to take place, and it appears that there will be more restrictions on jade mining. On top of that, just 4 days ago, Doubleview Capital publicly apologized for their actions against the Tahltan and have signed an agreement recognizing their rights. Despite the above successes, the province's archaic free entry mining laws remain in place. Lastly, it's worth emphasizing that British Columbia and the Tahltan Nation are both unique. Many Indigenous nations face additional challenges, and true reconciliation across Canada will require much more time and effort. With that said, we can hope that the recent victories of the Tahltan may signal what is to come elsewhere.